Welcome to all our delegates joining us live today on the TPN YouTube channel. We are pleased to present our COVID-19 in the Workplace webinar. My name is Peter Menon. I am the Head of Legal at TPN Credit Bureau. As per the previous webinar, the format for the 60-minute session today is as follows. We are going to run a 30 minutes of a practical discussion regarding the legalities and procedures of COVID-19 in the workplace, followed by a 15-minute showcase on the all-new COVID-19 documentation pack as sold as part of the HR employment pack of documents directly off the TPN shop. That link will also be in the description here under, ending with a 15-minute Q&A session. Just a few big administrative things before we get started. I will repeat these. However, in studio today facilitating the session is Greg Mason, our legal eagle. He is manning the YouTube chat room, as well as Brian Quinton from a help desk perspective. Michelle Dickens, the MD of TPN, is in studio facilitating the final Q&A session for today. And Richard Meyer, the director of Fullard Mayer Morrison and drafting attorney of the HR Pack documents and all new COVID-19 workplace plans and other ancillary documents, is also in studio today to showcase the new HR Pack documents as discussed. Please don't forget a couple of big ones. In order to get your CPD certificates, you need to complete the feedback forms, which will become available during the 15-minute Q&A. Right at the end, they'll be available for 45 minutes thereafter. So for an hour, that feedback form is available for you to go and fill out. Please do so to get your CPD certificates. You also need to be logged into YouTube to ask your questions in the chat. So make sure you log in, subscribe to the TPN YouTube channel, and give us a big old like. Just for today's purposes, remember, if the video or sound quality is not great on YouTube, go and have a look at your settings and put it at the highest level possible. Also, because we've moved into level 2 restrictions and the level 2 lockdown regulations, there is also a video available for you to go and watch that. It is on the TPN YouTube channel. Piet, Greg, or Michelle will put that up for you so that you can go and have a look at that after this session. With me today in studio is Dirk Pistorius, an associate from Fullard Mayer Morrison, a colleague, golf partner, and Dirk has oodles of experience and expertise in occupational health and safety and the legalities of implementation of workplace plans and other COVID-19 procedures. Dirk, we've had 850 delegates RSVP'd to today's webinar. Quite a lot, high stress. We're going to get through it. Obviously, an incredibly topical subject we're discussing today, with the national state of disaster extended from Saturday to the 15th of September, as well as South Africa moving into alert level 2. Compliance in the workplace is absolutely vital, and it's as important as ever. Because we're showcasing the COVID-19 documents today, Dirk, I would like to start off with the most practical question. Now, why the workplace plan? Why do we need a workplace plan?
Thank you, Peter. Thank you for the introduction. It's my pleasure to be here. It is no secret that we are facing tough times, to say the least. And added on top of that is, of course, the stress brought about in having to comply with so many rules and regulations that are often confusing and that are constantly changing. So I sincerely hope that we can put the viewers at ease as far as compliance at the workplace go. Peter, subsequent to the publication of certain regulations in terms of the Disaster Management Act, certain directives were also issued by the Department of Employment and Labour, which forces the employer to adopt certain measures to implement in his workplace. This could also be seen as an extension to the pre-existing obligation on the employer to provide his employees with a safe working environment that is without risk to their health. So Peter, so we realize that there is a need for this workplace plan. Employers do not necessarily know that they need a workplace plan, and I want to stop here and say it's not my opinion whether you need this workplace plan. It is peremptory, it's not permissive. The regulations use the word must. You must have a workplace plan in place. And a failure to comply with the Occupational Health and Safety Act could actually be seen as is actually deemed to be a criminal offence. Now, I'm sure many of the viewers may be moving around uncomfortably in their chairs at this point in time, and I want to say this and put them at ease. Have your workplace plan in place, and at the risk of stating the obvious, the just having a workplace plan is not enough. You need to actually implement it. But have your workplace plan in place and make sure it is compliant, and implement it, and you should be fine.
Okay, and we've obviously all seen this because we've been to shops and perhaps different businesses and perhaps went to the hairdresser, but what protocols and procedures must be in place in respect of symptom screening? Who must be screened specifically?
Yes, Peter, that is a question that we get a lot is, well, who do I need to screen? We know that you need to screen your own employees, and this extends to workers, also contract workers, and even volunteers. But the further question is then, well, do I need to screen anyone else that comes into the workplace, such as clients, customers, and that sort of thing? And I guess the default position is yes. Where it is practical for you to do so, you also need to screen visitors to your premises. To use an example of an estate agency, presumably they don't have hundreds of employees coming into their business every 10 seconds or so. So it is practical for them to do so. Remember, there's an obligation on you to protect your own employees. So where it is practical, you need to do so. I think we must remember that you can't not do it simply because it is a hassle. The exception to the rule would be typically be a large retail store, such as a Pick and Pay. It would be impractical for them to screen every person that comes into the workplace. Obviously, that does not mean they shouldn't do anything. They obviously still need to ascertain, well, is that person wearing a mask, and they should provide enough hand sanitizer and that sort of thing. But just to recap, it is your own employees, and where it is practical for you to do so, also other visitors to your premises.
Okay, and with the symptom screening specifically, we've seen the use of contactless thermometers, sanitizers at the entrance to the workplace, and sometimes even screening questionnaires. How is symptom screening supposed to be done in terms of these directions?
Well, the most common and easiest way to do symptom screening is by the use of the screening questionnaire. This is also included in the TPN workplace pack. This screening questionnaire lists all of the symptoms and comorbidities as defined by the National Institute for Communicable Diseases. And this questionnaire is then filled in, and the employee simply ticks yes or no at the relevant section. So the screening questionnaire is your first point of call in terms of symptom screening. As you've mentioned, there is contactless thermometers, and I do want to make a couple of notes on them, or mention a couple of things about them. Contactless thermometers is only really an additional tool in terms of symptom screening. For interest, the threshold of someone to be considered to have a fever is upwards of 38 degrees Celsius, but anything close to that should probably raise the eyebrow. Now, I think it's very important to note that just because someone does not or reports a fever, and his fever is taken, or his temperature is taken, and it is displayed to be normal, does not mean that that person does not have a fever, or that person is not symptomatic of COVID. We know that that person could have intermittent fever, he could have subjective fever, so he could feel feverish, but the reading is still normal. And I guess worst case scenario, your thermometer could be faulty. I recently visited a shop, and the shop steward unsuspectedly showed me my temperature to display a 31 degrees Celsius. So he didn't know he was witnessing a ghost, because I was clinically dead according to that reading. So just to get back to the point, the symptom questionnaire is your go-to procedure, and the thermometer is only really an additional helpful tool, and using both is obviously preferable.
So say, for example, a worker or a visitor or an employee of a company comes into the workplace, fills out the questionnaire, and either reports or displays COVID-19 related symptoms, are you obliged to show this person away? Are there exceptions to the rules? What is the protocol when somebody comes into the business and actually displays or reports these symptoms?
Peter, that is a rather contentious question and a difficult one at it. The directives are quite clear in this regard. It says that if any of these symptoms are reported or displayed, that person should not be permitted into the workplace. However, and I want to mention, this is just my opinion, but I believe that there could be a degree of flexibility and discretion. Let me use an example. Where one of my colleagues has a pre-existing eye condition. So he wears hard contact lenses and he always has red eyes. Mm-hmm. Now, if the legislation is to be strictly interpreted, he will never be able to return to the workplace. And so we believe that there could be a degree of discretion, but if you ask me what the directive says, it specifically says any of these symptoms, that person must not be permitted into the workplace. So I realize this may be unpopular advice, but the directives says what it says. And I think one of the important things that I need to mention is that COVID cannot be ruled out just by means of a clinical evaluation, even not by a doctor. So it can only be ruled out by a test. So I don't think the intention of the legislature was to give the compliance officer, for that matter, sort of the powers to decide who should come in and who not. But again, there could be some discretion, and I think one must remember that these directives and regulations were drafted in haste.
Yes.
And so it's impossible for them to cater for every scenario. So I think my advice to you would be to rather err on the side of caution if there's any doubt.
You asked me, strangely enough, yesterday when we were speaking, to bold this out specifically on my notes to ask you this question. But say, for example, the visitor or the employee is at work. They didn't display necessarily symptoms in the morning. They filled out the questionnaire. But during their time period at the workplace, they start to become symptomatic. What are the immediate steps? I know there's a lot of steps that you must implement, but what are the immediate steps that the employer must take when a COVID-19 or a suspected COVID-19 case is in the workplace?
Yes, Peter, I'm really glad you asked what the immediate steps are to take. There are many steps to be taken. I think there are about 15. They are all set out in the consolidated directives by the Department of Employment and Labour, dated the 4th of June. So Directive 20, this sets out all of the steps. But I guess it's important for the viewers to know what the immediate steps are to be taken. And so there's someone at your office that displays symptoms. There's panic and chaos. First thing you need to do is to isolate that worker. Put that employee or worker in a room that is well ventilated, that is disinfected regularly, that is not occupied by any other workers, and arrange for that employee to be transported away from the workplace, either to be self-isolated or to go for medical evaluation or testing. Also remember to do this when you transport this person, make sure that you do it so that it doesn't pose a risk to any other employee or the general public, for that matter. So that's the first step. The second step would be to disinfect that person's workstation.
And obviously the isolated area that person was in as well.
Yes, correct. Thirdly, you would need to assess the risk of transmission. So assess whether there was a risk of any of the other employees, for that matter, that if there was a risk for them to having contracted the virus. So you need to establish whether other employees are at risk, and if so, you also need to have them screened immediately. Thereafter, you need to undertake contact tracing. So this would typically entail phoning people who this person may have come into contact with. This is obviously when he is confirmed COVID positive. I want to make a couple of notes on disclosing a person's medical information. Actually, I can't go into it extensively, but there are certain legal limitations in terms of disclosing someone's medical information without their permission. So I guess my suggestion would be just to phone these people and let them know that they potentially, well, there was a person at your workplace that tested positive, without necessarily saying who that person is. In that way, you shift the burden in that you have done your duty in informing them of the risk, and what they do with that information is then up to them. Then you need to assess the risk, or assess the need to temporarily close your offices for decontamination or your premises for decontamination. Peter, I think I'm going to stop there. These are the immediate steps to take, and I think what I would also want to add to that is, especially with regards to the clinical management of that particular employee, I think it's important to consult a medical practitioner regarding, the typical thing: when is that person allowed to come back to the workplace? I think it's also important to possibly take legal advice into the secondary steps that one needs to take, particularly to report it to the Department of Labour when it is suspected to having been occupationally acquired. If this person was infected by COVID or with COVID at the workplace. So there are many steps, as I say, and yes, I'll leave it at that.
I was about to say, if we're going to go further into I'm going to put your cell phone number right at the bottom of the screen so that everybody contacts you about this. So for example, now taking this example further, the employee has now, you followed your first steps, you followed all those things. You touched a little bit on this regarding closure of a business, perhaps in certain instances where it's very, very high risk. But is it compulsory to close a business? I've seen retail stores across the road on the TPN WhatsApp. Somebody mentioned one of their retail stores actually closing as a result of a positive case in that specific workplace. Is it compulsory to close the business?
Peter, I think the short answer to that is no. It's not always compulsory. You need to determine the need to temporarily close for decontamination by following the Department of Health's guidelines. In some circumstances, it would be inevitable that you would need to close down your business. But let me use an example. Where a person, for instance, contracts COVID, and that person only, for instance, works in the guardhouse outside of the work, and it never comes into the actually comes into the office. It would be slightly over the top to have to close down the whole business, and it would probably be detrimental to your company, and that's not what the intention is. So you need to assess the risk by using an incident-based risk assessment and having due regard to the Department of Health's guidelines. As I mentioned, in some cases it may be inevitable. At the initial stages, well, we have a client that is a multinational courier company, and one of the employees contracted the virus, and this was at the initial stages of COVID. And so these employees refused to go back to the workplace unless the place was properly decontaminated. So in some circumstances it could be inevitable, but it's not compulsory per se.
And so, for example, we've got an employee who is at the workplace and he informs a manager that he's been in close contact with a person that is confirmed to be a COVID-19 positive case. What's the protocol that needs to be in place there? So what happens when an employee actually is in contact? Talking about self-isolation, talking about quarantine a little bit.
Well, Pieter, I think one of the myths that I would want to bust is that just because you've been in contact with a person that is confirmed COVID-19 positive, doesn't necessarily mean that you cannot, as a rule, return to the workplace. We first need to establish whether there has been a high risk of exposure or low risk of exposure, and these guidelines are set out by the Department of Health. So just to quickly explain the difference between a high risk and a low risk of exposure. A high risk of exposure was where that contact was within a meter of each other, and it was for more than 15 minutes, and the person was not wearing the appropriate PPE, such as a mask. So that would be considered high risk. A low risk is where there was contact at a greater distance than a meter, or even if there was contact within a meter for more than 15 minutes, and even if there was a close contact, the person was wearing the appropriate PPE. So there is a distinction between a high risk of exposure and a low risk of exposure, and that needs to be ascertained first and foremost. Once that has been established, then certain steps need to be followed. So if there was a high risk of exposure, so let's use an example, two persons were traveling in a car together, they were within 1 meter of each other, they traveled for more than 15 minutes and neither of them were wearing the appropriate PPE. That would be considered a high risk of exposure, and that employee needs to be placed in quarantine and should not be permitted to come back to work. However, if there was a low risk of exposure, so it didn't tick all of those boxes of criteria, if you want to call it that, then that person can be permitted to continue with work, obviously adhering to the standard precautions and wearing a face mask and that sort of thing. And they also need to self-assess regularly, and if they develop any of the symptoms, they need to immediately be referred to testing.
Probably one of the most practical and biggest questions that is facing our clients is with this entire compliance procedure, there's the scary thought of if the Department of Labour and their inspectors show up, what are they busy looking for in a business? Is it that everything is absolutely done to the T, or are they looking for something different? In light of compliance, what are those inspectors actually looking for?
Pieter, I would think that they would be looking at, well, firstly, do you have your workplace plan in place? Is your workplace planning compliant, and does it contain the risk assessment? Further to that, they would probably be looking at, do you have sufficient amount of hand sanitizers? Do you have your posters up as included in the TPN pack? So the standard things would be, firstly, to look, do you have your written workplace plan? Do you have it in place? And second of all, are you actually implementing it? Are you taking steps to the virus?
Which is everybody's obligation at the end of the day.
Absolutely, it's absolutely everybody's obligation, but the obligation is specifically on the employer to enforce it. I don't think the inspectors would have the attitude of catching you out. So they would want to see that it is in place and that you are making an effort to implement it. Now, that being said, we know that it is a reality that on-site inspections are carried out on a daily basis, and it should not come as a surprise if you were to be visited by the Department of Labour. I guess employers are also worried about forced closure, which could also happen. And Section 30 of the Occupational Health and Safety Act sets out when a business could be forced to be closed down by an inspector. And this will be where there are no measures in place and where there's an imminent risk to that person's or the employee's health and safety. And so I want to say this: if you have your workplace plan in place and you are implementing it, you should be okay. There shouldn't be a prohibition notice issued to you by the Department of Labour.
Thank you so much for setting our minds at ease a little bit over there. So just as a rundown before we switch over to Richard and that showcase, obviously common sense, risk assessment and the mitigation of said risk is vitally important. But compliance through properly drafted documents is so vital at this point in time, because that's actually what the inspectors are going to go and have a look at. Yes, the implementation, but also that the procedural compliance steps have been dealt with.
Yes, absolutely, Peter. I think having a well-drafted and compliant workplace plan in itself is already a couple of steps in the right direction in terms of compliance. I think the prevailing theme is also that common sense should always prevail when enforcing these or when implementing these procedures and plans at the workplace. So I think if that answers your question, I think compliance in terms of your paperwork is important. And again, I've mentioned it before. If you have your ducks in a row, you have your paperwork in order, and you are making an effort to actually enforce these or implement these workplace plans and so on, you should be fine.
Thanks so much, Dirk. Don't forget, in order to get your CPD points, you need to stay for the end. There is going to be that feedback form during the Q&A session. It's available for the hour. And remember, you need to be logged into YouTube to answer or ask those questions in the chat. Without further embellishment, we're going to move over to Richard, who's going to showcase those COVID-19 documents. Richard.
Thank you, Peter and Dirk. I'm Richard Meyer. I'm a labour law attorney with the firm Fullard Meyer Morrison, and I helped draft the TPN COVID-19 package, which is an addition to the TPN HR pack. And the TPN COVID-19 package is a response to a direction of the Department of Labour issued on the 4th of June. The direction requires employers to engage in a risk assessment of the workplace to avoid the transmission of COVID-19. On the basis of that risk assessment, the employer must then implement a workplace plan to mitigate or eliminate the risk of transmission of COVID-19 in the workplace. And then thirdly, the employer must engage with employees and representatives regarding the workplace plan, and then also take steps to inform employees of the contents of the direction issued by the Department of Labour. Subscribers to the TPN HR pack can obtain the COVID-19 package automatically, but if you have not subscribed to the TPN HR pack, you can obtain the HR pack including the COVID-19 package at the cost of 920 Rand. And without further ado, let me take you through the COVID-19 package. And I should point out that if you already have a workplace plan in place, well and good, but the package will assist you to check if your systems and procedures are properly in place and are adequate to deal with the contents of the direction. But obviously, if you don't have such a plan and you have not opened for business, this will assist you greatly in this regard. So first and foremost, I'm going to take you through the workplace plan. You'll see that it's a standard document in accordance with the format of the TPN HR pack. It has a schedule where specific information is inserted with regard to the specific requirements of the particular employer. There's a definitions and interpretation section, and then the body of the document relates to the risk assessment and the consequent workplace plan. So if I can then take you through the schedule, there's certain details that must be entered with regard to the specific workplace, and there should be this assessment done with regard to each individual workplace with its own specific requirements. An important aspect of this schedule is the usable floor area, because that is important to determine whether there are perhaps too many employees in the workplace to ensure that the risk of the transmission of COVID-19 is eliminated as much as possible. And then another important factor is entrances to the workplace, because these must be controlled and proper screening must be done of visitors and employees in the workplace when they attend in the workplace. Clause 1.1.10 is the compliance officer who must be appointed in order to ensure compliance with the workplace plan and with the direction issued by the Department of Employment and Labour, and the date of the anticipated reopening of the workplace or when the workplace actually opened. And then there are a number of risk assessment factors which must be taken into account in developing a workplace plan. We set them out there, and in particular, one must look at whether the workplace has adequate usable floor space, which is one person per 1.5 meters of floor space, or one person per 2.25 square meters of floor space, if one works that out. An important aspect of the risk assessment is the presence of vulnerable employees in the workplace, and that must be assessed, and then adequate measures must be taken in the absence of usable floor area to ensure that proper protective measures are in place, and these would include the arranging of physical barriers, supplying employees with appropriate personal protective equipment, and the rotation of attendance of employees at the workplace to ensure that as few employees are in the workplace as possible to prevent the spread of the virus. An important aspect of the employee details that must be inserted are the number of employees who may have been tested for COVID-19 at the workplace. And in this event, the company must implement certain steps, such as informing the Department of Health or the Department of Employment and Labour, which is mandatory, then investigate whether the protective measures in place are adequate, also determine whether there's a need to temporarily close the area affected where the infection occurred, and implement remedial measures if necessary, and also give administrative support for any contact tracing measures that may be implemented by the Department of Health. An important aspect of the list of company employees is the age of the company employee and their comorbidities, because employees over the age of 60 are considered to be vulnerable, and those with comorbidities are automatically vulnerable. Then special measures must be set out to address the needs of vulnerable employees, and in particular, if vulnerable employees cannot work from home, the reason why, and the temporary workplace accommodation of vulnerable employees must be addressed, and a number of accommodation measures are set out there which can be implemented. Finally, if vulnerable employees cannot work from home and cannot be accommodated in the workplace, there's a number of leave procedures which can be adopted, and one of which would be the temporary incapacity of the employee for the period of the epidemic, then the employment of sick leave or annual leave, and if absolutely necessary, unpaid leave can be recommended for that employee, but it's not something that the Department of Health believes should be done and should be a last resort. In addition, because the employer must ensure the protection of subcontractors who attend at the workplace, one must go through a list of potential subcontractors, and the risk assessment must consider whether the subcontractors work inside or outside the workplace, because obviously there's a lesser risk if the subcontractors are outside the workplace, their age, and whether they can work from home, and various comorbidities that they may be subject to. In the definitions, the only aspect that I think should bear particular attention is the aspect of vulnerable employees, and in this regard, employees, as we've seen, 60 years or older are automatically considered vulnerable, and then the other conditions which render employees vulnerable are chronic lung disease, diabetes, moderate or severe hypertension, serious heart conditions, chronic kidney disease, chronic liver disease, severe obesity, immunocompromised employees, and where one is dealing with female employees if they are over 28 weeks pregnant. And then if one looks through the body of the document, there is the risk assessment, which appears at clause 6 and subclauses, and then there is the workplace plan at clause 7, and in this regard, these two aspects of the document should be read in conjunction with the schedule to ensure that they are synchronized and that you have taken steps to ensure that the various requirements set out in the workplace plan synchronize with the risk assessment and the information you've provided in the schedule. If I can then switch to the supporting documentation which relate to the workplace plan. We then have the COVID-19 screening questionnaire, which should be employed for people entering into the workplace, including employees, contractors, and visitors. And an important factor here is the recorded temperature. The practice appears to be that if the recorded temperature is over 38 degrees, that person is a risk because they have a fever, which would probably mean that there is a high chance that they are subject to the COVID-19 virus. And then there are other symptoms that must be assessed, and if some of these symptoms or all of them are in evidence with the visitor, that visitor should not be allowed in the workplace. Then there is a workplace register of visitors, and this is essentially to keep records in order to ensure if there is a need for contact tracing that such visitors can be traced and tracked in order to minimize the risk of their spreading the COVID-19 virus further. Another document which is a part of the COVID-19 package is COVID-19 COIDA reporting information, and this relates to occupationally acquired COVID-19 in terms of COIDA, which stands for Compensation for Occupational Injuries and Diseases Act, and you'll see that the document gives an explanation of what is COIDA, what to do when a case of COVID-19 is suspected, and how to report a claim in terms of COIDA. Finally, part of the COVID-19 package is a list of posters and notices which should be displayed in the workplace in terms of the direction in order to inform employees of the risks of COVID-19 and the various measures to eliminate or reduce the risk of its spread. And you'll see the document has an explanation of what is COVID-19, how it is transmitted, what are the symptoms of COVID-19, how to use a mask, how to wash hands, measures to keep the workplace safe, procedures for self-quarantine under COVID-19, frequently asked questions which are answered regarding COVID-19, an explanation of the difference between physical distancing, isolation, and quarantine, and measures to stop the spread of COVID-19 for employees. So this is an overview of what is to be done, and although I want to point out that I don't think it's the intention of the Department of Labour and Employment to conduct a witch hunt, there are criminal sanctions available if you do not comply with the direction, but if you do employ these procedures, the risk of an adverse attention from the Department of Employment and Labour is substantially reduced, and one would protect oneself adequately by complying with the provisions in the TPN COVID-19 package. So thank you for listening to me, and I just want to bring it over to Dirk and to Peter. Thank you.
Thank you very much, Richard. I'm sure a lot of time and a lot of effort went into drafting those documents, so we thank you very much for that. Please don't forget, the feedback form is going to go live right now. You can go and fill that out for us. It's going to be live for 15 minutes during the Q&A session that we're going to head into right now, and also available for an hour afterwards. So please go and fill those out for your CBD certificates. Richard and Michelle, will you please assist us in the facilitation of questions for the next 15 minutes?
Thank you, Peter. We've got a first question from Natasha Buerta, and perhaps I can direct it to Dirk. She asks, should only one person in the company be appointed to do the screenings?
Is it Natasha? Natasha, I think, no. I think you need to have more than one person. Obviously, when that person's not there, there should be someone else that could fill in to that place. Also, if you do not have, or if you have more than one entrance into the premises for that matter. So there should be, ideally should be more than one person, depending on your circumstances.
Well, it obviously wouldn't make practical sense just to have one person, because what if that person's off work or not necessarily in the office? So
yes.
definitely more than one.
So Dirk, then another question from Mariana Gunn, and she asks, if an employee tests positive and had access to the workplace, what is required in terms of sanitizing the building or closing the office, and for how long?
I think I touched on that when we run through the initial questions, and well, the protocol is to determine by using an incident-based risk assessment by having due regard to the Department of Health's guidelines in terms of decontamination. They are quite extensive, so it's impossible for me to say how long and that sort of thing. You need to consult the Department of Health in this respect. Just quickly, as I mentioned, it is not always a requirement to decontaminate, but the question of whether you should contaminate or not, you should absolutely decontaminate. So I think that partially answers your question, but unfortunately I can't give you a direct answer to that. You need to consult the Department of Health in terms of their own guidelines, in terms of, it would depend on how many have been infected, where the infection possibly took place, where this employee moved around within your premises, that sort of thing.
And like you said, based on obviously the risk factors involved, it's not necessarily compulsory to close the business. It might in certain instances not be a requirement.
Yeah, not always. It's not always a requirement to close down. I almost want to say in most circumstances you would inevitably have to close down. It would be difficult to keep on working when someone is over the top of you and cleaning and that sort of thing. So, but it's certainly not always necessary to close down for an extended period of time.
Okay. And then following up, Shani van der Walt asks, what if someone has a temperature above 38 degrees, Dirk?
Well, above 38 degrees, as far as I'm informed by a couple of doctors, is considered to be a moderate fever. A fever, as we know, is one of the symptoms of COVID-19. And so that person must not be permitted to enter the workplace.
So if I can just interject there, I noticed that when I attended at the bank recently for the first time, they were not allowing people access to the premises over 37.3. So they were erring on the side of caution.
Absolutely, very much so.
And then we have a question from Jackie van Staden. Is there a standard recommended documentation that can be used to document all people entering the workplace? If so, how can we get hold of this? And I can just say as a source of comfort that there is a document dealing with this in the COVID-19 TPN pack, so you've got something to use there, which is a register of all persons attending in the workplace.
Richard, just to give some practical insight into that as well, remember, as a TPN subscriber, if you are subscribed to the TPN HR pack, those documents are directly available for you through the HR pack. If you're not a HR pack subscriber, you can go into the TPN shop and go and subscribe to that HR pack document, so that your COVID-19 documents are also available to you.
Thank you, Peter. And then we have a question from Anita Kelly. How can we get a copy of the symptoms questionnaire just to compare with the one we already use at our office? And once again, that is included in the TPN COVID-19 pack, and you do have a symptoms questionnaire which you can then compare. It contains the requirements as contained in the direction of the Department of Employment and Labour in the pack as well. And then we have a question from Shani van der Walt, who asks, how many employees are required for a workplace plan? Dirk, can you answer that?
Yes, if you have 10 or more employees, you are required to have a workplace plan, unless you are specifically excluded from the Act. However, I do want to mention that even if you have less than 10 employees, a basic plan and a basic risk assessment is also necessary. So, to be honest, my view is just to have a comprehensive workplace plan in place in any event, but the directives specify 10 or more employees, then you need a workplace plan. Less than 10 employees, you do still need a basic plan and you still need to conduct a risk assessment.
We actually had this discussion yesterday regarding comprehensive or basic plans, but using a basic plan would basically be like using a basic lease agreement. So we would suggest using a comprehensive plan in those circumstances, correct?
Sure, you can't go wrong, and I mean, COVID compliance, if you want to call it that, is going to be with us for the foreseeable future. I think Richard and I discussed it yesterday. Even if there's a termination of the state of disaster, we don't think it will be uplifted per se, or not be compulsory within the workplace. I think it's going to be with us for a long time to come.
Okay.
So thank you for that, Dirk. And then Celeste asks, and this is something that you might want to think about, it's more of a medical question and we can debate it. Has the World Health Order now downgraded COVID to a normal flu?
I don't think so, but I'm not sure. Look, I'm not a medical doctor, and they call it the novel coronavirus because there's so much information that is still unknown about this virus. But I don't think that it would be downgraded to a normal flu. I simply don't think we would have reacted to a normal flu as we have to COVID.
Dirk, I must agree with that. I don't think you can equate COVID to a normal flu. I think its impact is far more serious, and the disabilities and the death that it has caused in the country and the world as a whole cannot be compared to flu. So I agree with that completely. And then Brenda Schmidt asks, is a workplace plan essentially your standard operating procedures? Do you have a view on that, Dirk? So is a workplace plan essentially standard operating procedures?
Well, it's that, and it's more. It's also measures to put in place to protect your employees and to prevent the spread of the virus. Now, actually, the directives specify the prevention of the spread of the virus, and I think I need to mention something quickly. I don't think that it is possible to eliminate the possibility of the spread within the workplace. I think what is important is that you mitigate the risk of transmission. We've seen that you can do it if you implement your workplace plan, you practice social distancing and that sort of thing. It is effective. So it's not your standard operations. I mean, it's a new thing for that matter, but it is an extension to your pre-existing obligation in providing your workers with a safe working environment. So it is in a sense pre-existing, but it's also new in another sense.
And then we've got a question from Remax Property Associates, and it goes to timing of decontamination. And the question is, does one decontaminate when the staff member tests positive or when they show symptoms and are sent home?
Look, I think the prevailing theme about this is always to use your common sense and always rather be more cautious, err on the side of caution. So I think immediately if there are symptoms, do the decontamination or disinfect that workstation for that matter.
Yeah, I think the thing here is you can go overboard and sort of prevent something rather than going underboard and have something occur later on that you're worried about. So So rather follow the procedure to the strictest sense, or to the strictest time periods that you can.
Yes, absolutely. I think I mentioned this. Section 8 of the Occupational Health and Safety Act obliges the employer to keep to provide a safe working environment, and I think that just follows on to that, and that you need to take the minimum steps to provide, and in providing a safe working environment that is without risk, I think is doing a decontamination once symptoms are displayed, not necessarily when testing is done. Also note on that testing can take up to a week to come back, to get back. So there could be a lot of COVID within your workplace, and you could know about it by doing symptoms or by someone being symptomatic. But I think it would not be reasonable for you to wait until those tests come back eventually and not do anything. So I think immediately decontaminate if you can.
Good answer. I like that.
And then, Dirk, a very important question regarding the basic obligations of the employer in the workplace. Chanel asks, does the employer have to provide PPE, i.e. masks, hand sanitizer, etc., to the employees in order for them to be in the office?
Yes, and it's free of charge to the employees. You need to provide at least 2 surgical masks to them, and depending on in which sector you work and depending on your circumstances, if extra PPE is required, you also need to provide those employees with those PPE free of charge.
And then quite an interesting question which we'll debate from Marie Leroux. How does this apply to residential complexes where all services are contracted and not employed by the body corporate?
Could you just repeat that question?
So essentially where one has a body corporate and you've outsourced the services, such as, I suppose, access, security and the like.
Just
so
could you
for
formulate
example,
this
you've got a body corporate and they're tenants and obviously owners in the body corporate itself, but the body corporate has a responsibility for the upkeep, for maintenance of the gardens, for security perhaps. So inherently they won't be employees of the body corporate, but they're contractors of the body corporate.
Yes, Peter, I think you hit it on. You hit the nail on the head there. Workers is defined in the directives to be your own employees, but it also extends to contract workers, volunteers, also the self-employed. So I suppose that a body corporate could be deemed to be the employer of a contract worker coming into the premises or the complex, and for that reason they could also have an obligation to, for instance, screen and not permit them into the workplace, if you will.
I love Richard asking us employment questions.
Yes.
Okay. And then there's another question from Remax Property Associates. Would estate agents who are independent contractors get issued PPE? So
I think that's very similar to the previous question.
Yes, Richard. I think I may refer this to you since you are the labour expert.
Well, my basic approach, as is yours, and the general approach of our firm is, if in doubt, err on the side of caution. So ensure the provision of PPEs, because one is protecting anyone who's coming onto the workplace and people who are on the workplace. So it's protecting both people there and coming into the workplace. So if in doubt, provide the PPEs.
Yes, agreed.
And then Robin Cronier asks, what leave will get used if an employee is sent home with a symptom or office is shut down for sanitizing if annual leave has been utilized during lockdown? And the question is it no work, no pay? Well, my approach to that is if someone has symptoms and they go home, they've exhausted their annual leave, then obviously they would be entitled to sick leave. It's a bit more of a grey area for shutdown for sanitizing, because that is something out of the control of the employer. But the shutdowns for sanitizing should be a short period, and I would recommend the provision of sick leave in such circumstances. But often the sanitization will simply be a matter of a portion of the office, not the whole office. So the short answer is sick leave is available for people who show symptoms of COVID.
Yes, Richard, and if I can add something to that, it's specified in the directives that if such a person where there was a high risk of exposure, as we explained, and that person was placed in quarantine, the position is that that person is then placed on paid sick leave. And as Richard mentioned, if that paid sick leave is then depleted, that employer should apply for temporary employer relief scheme funding, so TERS funding.
Richard, just sorry to get back to the COVID-19 documents. That forms part of the COVID-19 workplace plan, doesn't it?
That is correct. There is a sequence of aspects or forms of leave that are available, and one starts with the annual leave, moves through into sick leave, and then there are other forms of leave available, such as the TERS benefit, which is available where employees couldn't attend at work because of the shutdown or because of the circumstances in which the employer finds themselves because of the regulations. And then we have another question from Natasha Buerta. Should the compliance officer be an HR manager or an SHEQ manager or any other employee? Do you have a view on the status of the compliance officer, Dirk?
Richard, it's an interesting question. I don't think, as far as I recall, I don't think the directives specify who needs to be the compliance officer. It's not necessarily an HR manager. I think it would be practical where you make the HR manager the compliance officer. It obviously falls more sort of within their expertise, but I don't think the directives specify that the HR manager, for that matter, must be the compliance officer.
I agree with that. I think any manager or any employee, but preferably a manager because of the seniority that attaches to the position, should be the compliance officer. And then we've got from Ruvaneshri, and she asks, who is responsible for the testing costs, Dirk?
Well, it's an interesting point, and I think we have differing views. What I've seen is that the employer is not necessarily responsible for the testing costs. I also believe that it could be obtained free of charge at the public hospitals and that sort of thing. But Richard, let me refer this to you as well. You may have a different view.
Richard, just to ask, this is going to be our final question before we end off. So, oh, fantastic! We've actually got 3 minutes left. Go for it.
Excellent. Well, I would suggest that ultimately it's the employer's responsibility to ensure a healthy and safe workplace. So if there is doubt, the employer should cover the testing costs, particularly if the employee is someone who cannot afford such testing costs. And then Mariana Gunn asks an interesting question. Why must we capture the ID number, Dirk? That's on the register of visitors to the workplace, obviously.
Well, it goes to contact tracing, really. Look, I think contact tracing per se, look, you should still do it, but I think contact tracing initially was very important, where there were a few number of cases reported. So where you could sort of ring fence those particular cases and see where the contact, happened. I'm not exactly sure if the capturing of ID numbers is such a requirement anymore, but to give you an idea, that is to be able to pinpoint who was in contact or who could have been the source of the COVID, if you will.
Okay. And then we've got a question which doesn't really go to employment, but I think we can venture a view on it, from Jean Kruger. She asks, on holiday letting, do houses need to be sanitized before and after, or only if someone has been contaminated? So I think the question is, does one sanitize before one has a case, or only thereafter?
Well, look, I think this isn't really a very legalistic answer, but I think a common sense approach should always be taken. And you need to do whatever you can to prevent the spread and to keep people safe. So I think before this person enters the holiday place, do so and do the sanitizing.
I agree with that, Dirk. Prevention is better than cure.
Absolutely.
Thank you so much, both Richard and Dirk, for joining us in studio today. I'm sure the clients found it as insightful as I have, hearing your arguments from both sides and obviously having that specific discussion. It was absolutely fantastic. Thank you very, very much for joining us today. It's been an absolute pleasure. And like I said, from everybody at TPN, thank you very much for joining us. Please stay online. Remember to fill out that feedback form for us for those CPD certificates. And subscribe to our YouTube channel, please, for more insights in properties, schools, as well as further legal insights into the COVID-19 pandemic. Thank you very much for joining us. Have a lovely day further.